Hello and welcome to the ePathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. We are going to discuss a module on exhaustion of intellectual property rights. Let me provide you a brief outline of the whole module that we are going to discuss in this brief 35 minutes. So we'll start with the premise that property law envisages in relation to sale and what does it mean to impose absolute conditions on sale, what it means to have first sale doctrine in intellectual property law, different kinds of intellectual property involving patents, copyrights and trademarks, whether there are any exceptions to first sale, and what would it mean to have a regime of exhaustion, either national, regional or international. We'll also discuss arguments both for and against international exhaustion. We'll discuss some of the issues surrounding the TRIPS agreement in relation to Article 6 and the principle of exhaustion that countries can follow within their domestic laws, whether TRIPS does or kind of envisage any particular kind of exhaustion or not, and what are its relationship with dispute settlement will be discussed in this particular slide. We'll also discuss exhaustion of patent rights in India, exhaustion of copyrights in India, exhaustion of trademarks in India, followed with a specific discussion on exhaustion of self-replicating technologies. We'll look into the Bauman versus Monsanto decision delivered by the Supreme Court of United States a couple of years back. We'll also discuss exhaustion of copyright infringing products, where the object of the sale of the product or importation of the product into India is necessarily not the copyrightable work itself. So in relation to ancillary works, how does copyright law envisage exhaustion will be discussed in this module. Finally, we'll end up with a brief summary of issues that we have discussed and kind of conclude with some understanding of the regime of exhaustion and the future of exhaustion in India. One of the important principles in relation to the sale of property is that the property vendor may not impose any absolute condition on sale that defeats the very purpose of deriving value from such property, either in land or in chattels. This principle has its basis in the fundamental fact that any such absolute condition on further reselling the product will not help the buyer in actually realizing the value of the property. If you look into the rights that are granted to property owners, primarily they include a right to use and exclude the property and to convey the property. Hence, any such conditions on conveying the property will kind of impose absolute restriction on the ability of any buyer to enjoy the property in its fullest sense. Now, this principle has been extended in relation to IP, which is called as the first sale doctrine, which means that any kind of argument in relation to first sale would involve a situation where the buyer of a product in which there is some kind of IP embedded, either in the form of patent, copyright or a trademark, has absolute right in terms of further selling or reselling the product, and the IP holder loses his ability to pursue such product. This particular principle of first sale derives its basis from property principles, as in land and chattels, and it primarily includes a situation where the buyer of any IP protected product can further sell it. However, the IP first sale doctrine applies in relation to the exact copy of the product that is sold to him, and not he may not replicate further products or distribute them without the permission of the intellectual property holder. So the first sale doctrine, it's clear, only applies to that particular product which has been sold and not to any other product that he may make copies, because that would directly conflict the right of reproduction and other kinds of distribution rights involving the IP rights holder. However, there are certain notable exceptions to first sale. One of those exceptions is that in relation to a computer program or a sound recording or a cinematographic film, the first sale doctrine shall not apply. And this is very clear from one of the decisions of the Delhi High Court in Santosh VG, where the defendant was running some kind of a video parlor or rental service, and the defendant was renting out his CDs and DVDs, and which were lawfully sold in United States and Canada. The defendant used to import those CDs and sell them here for a rental fee. Now, in this case, the plaintiff, which was a leading film production company, in the United States filed a case alleging that defendant in India had no rental licenses in his favor, and that all acts of rental would amount to a copyright infringement under section 14 clause D clause 2, read with section 51 of the act, which deals with infringement. Now the contention of the defendant was that all of its CDs and DVDs were legally authorized to be sold within USA, and hence the first sale doctrine would apply. Now the court said that this first sale doctrine, which is allowed under section 14D read with clause 2M, incorporates a principle of first sale doctrine. However, it does not apply to classes of works which are not mentioned in that particular clause. So section 14, the court took note of section 14 and said that copies not already in circulation would definitely mean that there is a first sale doctrine. However, such in case of cinematographic film, making unauthorized copy of the film or selling it for hire would mean that would amount to an infringement, and hence specifically in the context of cinematographic film, where there is a clear rental right enshrined in the act, the first sale doctrine would not apply. Now, apart from these notable exceptions to first sale in situations like computer programs and cinematographic films and sound recordings, we understand that this obligation is also there in the TRIPS agreement, article 12, which talks about rental rights in relation to computer programs and cinematographic films and sound recordings, but it is left to member countries to decide only where there is certain amount of damage that is occurring to the right holder. Now India has exercised this particular right in favor of IP holders, and clearly provides that fair use doctrine may not prevail, and this VG Santosh decision decided by the Delhi High Court in 2009 is pretty much clear. Now there are certain principles of first sale when applied to national, it's called as a national exhaustion, and when applied when there is a first sale internationally, it's called as international exhaustion. By this we mean that in a situation where there is national exhaustion and or countries that follow national exhaustion, any importation of IP protected product elsewhere would amount to an infringement of a territorial right. It means first sale doctrine is territorial in nature, and that the defendant, the importer, may not rely on the fact that there was a valid sale outside the particular territory. Now this is the case of national exhaustion. In case of international exhaustion, any first sale outside the particular territory or any part of the world would exhaust the right of the intellectual property holder, and hence by virtue of this, parallel importation of the IP protected product would be allowed. Now there are certain arguments both in favor and against international exhaustion. The arguments against international exhaustion primarily are owing to the fact that IP owners would be specifically discouraged from price discrimination and segmenting the markets. So it would mean that all those products which where there would be a price arbitrage, IP protected IP owners would be restrained from price discriminating, because they are not encouraged to do this by virtue of international exhaustion. Similarly, there is a worry that any kind of price discrimination may discourage IP owners to take measures that relate to kind of advertising, or those that involve specific local vendors where they invest quite a lot in the sale. So these there are free riding effects of international exhaustion, and those need to be taken care of. But otherwise there are specific positives and specific advantages of having an international exhaustion regime, especially for a developing country like India, wherein you can have access to the cheapest material that is derived through first sale in any part of the world. Now TRIPS agreement has nothing much to say about the regime of exhaustion that countries can follow, except that article 6 says that in relation to any regime of exhaustion that countries might want to follow, article 3, that is national treatment, and article 4, that is MFN, shall be followed. Primarily it means that you may have national or international exhaustion, however you shall not discriminate between nationals, and if you provide a particular regime of exhaustion to one particular member, then that particular regime of exhaustion shall be extended immediately and unconditionally to all members of the WTO. Now there is a kind of argument whether certain provisions of Indian Patent Act in relation to exhaustion would violate the TRIPS agreement, primarily because of the fact that since exhaustion is not defined, and if it runs contrary to the right of importation, distribution and other kinds of rights that are clearly envisaged in the TRIPS agreement, whether there would be any kind of such violation. Let's look into the Patents Act for a moment and see how the regime of exhaustion is designed in patent law. Section 107 clause A of the Patents Act says certain acts not to be considered as infringement. For the purposes of this act, the importation of patented products by any person from a person who is duly authorized under the law to produce and sell or distribute the product shall not constitute an infringement. Now, by virtue of this provision, it allows any price arbitrage of a product that does not have a first sale in any part of the world, in the sense that for a first sale doctrine to kick off, it has to be sold by the IP owner. But in this case, in the Indian case, by virtue of who is duly authorized under law to produce, would mean that it could be any person other than the IP holder who makes a first sale, and hence there is a question whether such kind of importation into India would violate section 48 of the Patents Act. Now this becomes also TRIPS contentious because certain rights that are granted under Article 28 may run primarily contrary to the exhaustion regime that is enshrined in section 107 clause A, B of the Act. So this particular provision is highly TRIPS contentious in the sense that who is duly authorized under law, if it has to include any other person than the IP right holder, and by virtue of a first sale from such other person who is duly authorized in law in a particular country, and such products, if they are imported into the territory of India, may violate section 48 of the Act, which is in turn reflective of the provisions of Article 28, which lays down the rights of the patent holder. Now there is some contention as to whether India's regime of exhaustion is unique, or whether India's regime of exhaustion is actually what is primarily enshrined in comparative jurisdictions in other countries, including the TRIPS agreement. Since I mentioned the TRIPS agreement has nothing much to say about exhaustion, let's look into briefly how other countries have structured their exhaustion. Most countries, including the United States, have national exhaustion enshrined within patent laws because they want to guard patent laws very strongly than other kinds of rights. So although there is a first sale, the first sale is territorial, and hence national exhaustion kicks in. However, in one of the decisions called Merck versus Steffer, decided by the European Court of Justice way back in the 1980s, it says that wherever there is a first sale in a country where the patentee has taken the risk, in spite of the fact that he does not own a valid patent there, has put the product in the market, the exportation of such products outside a particular country and importation into the other country would not constitute an infringement of the patent right in the country in which it is imported. Practically means that a situation similar to India, where exhaustion would kick off by virtue of the fact that a person, although there is no intellectual property, and if he puts the product into market, would not be entitled to raise a contention that his rights have been infringed. This Merck versus Steffer decision is kind of unique because the court's argument was A, that there should be free trade within the European communities, and second B, that since the patent owner himself took the risk of putting the product in the market, wherein there was no valid patent that was granted, the rights would get exhausted by virtue of the first sale by himself. Now if you apply this particular decision in the context of India, section 107 clause A, clause B seems, although contentious with reference to TRIPS agreement, but there are certain other practices followed in comparative jurisdictions which are equally contentious. However, it may be noted that this Merck versus Steffer decision was one in its case, and it has not been followed largely in other parts of the world. Moving on to the exhaustion regime of copyrights in India, one of the important decisions in relation to exhaustion is the decision in Penguin Books. Here the plaintiff was a leading publisher of books, and he entered into several agreements with the copyright owners, which the plaintiff claimed assign rights over his works exclusively, and in relation to printing and publishing of these works to the plaintiff in India. The plaintiff alleged that the defendants imported the books from those countries and were offering for sale in India. Hence defendant were infringing the copyright owned by the plaintiffs. The defendant opposed this kind of argument by the plaintiff on the ground that there was a consent decree in the United States where they were allowed to sell the product lawfully. However, the division bench felt that the consent order was not a material fact and it was confined in its operation to the territory of United States. The plaintiff could not be bound by the decree, and hence the rights under Indian law were to be strictly construed. So coming to the Copyright Act of 1957, the courts interpreted section 51 in a very unique fashion to mean that any importation of infringing copy would amount to infringement unless it was for the importer's own use. Now therefore an action which did not involve the copyright owner's consent and importation of such books without the consent or without the permission of the copyright holders and without his exclusive license would mean infringement. Now this particular decision raised many issues, and the interpretation of specifically section 51 clause B clause 4 read with provision 2M meant that in relation to copyright India followed a national exhaustion regime. However, this particular section 14 was amended in 1994 post the Penguin Books decision to include the first sale doctrine, and some have argued that by virtue of section 14 being amended and inclusion of the first sale doctrine, the first sale doctrine is not just territorial but it is international exhaustion. Unfortunately, the courts have not understood the import of this amendment, and in Eurokids International versus India Books Distributors Limited, a case decided in 2005 by the Bombay High Court, the court has come to a conclusion by relying again on Penguin Books that section 4A2 provides for a fair use for a first sale doctrine. However, it's limited to national exhaustion when read along with the meaning of infringing copy in section 52B4. Interestingly, the courts have gone ahead in India to provide parallel exports as such, and this concept is very unique because most countries allow exportation of products without the consent of the patent holder, because anyway it does not infringe the rights territorially. However, in this case of John Wiley and Sons versus Prabhat Chander Kumar Jain, a case decided by the Delhi High Court in 2010, the plaintiff was a leading publisher of academic scientific journals which had a wide circulation, and he came out with a low priced edition of the book in Indian market. These editions were meant for sale only in India and South Asian nations. However, the defendant exported those books outside the country. Now the plaintiff alleged that copyright infringement against defendant who was exporting these low priced editions, and granting an injunction in favor of the plaintiff, the Delhi High Court said that the right of the owner of the copyright to issue copies of the work to the public would not be circumcised by any territorial limitation. Thus the owner of the copyright would have the worldwide right to issue such copies of the work. Now this primarily means that the court has completely got this particular proposition in an erroneous fashion, because section 14 clearly says that copy is not already in circulation. It means what you do with the copies in terms of either selling them within India or outside India is left to the buyer and not to the IP holder. Now this particular view is kind of per incurium when you consider the actual meaning of an import of section 14A clause 2. Owing to the fact that many court decisions in India have interpreted section 14 to mean first sale as applied to Indian territory and hence national exhaustion, Section 2M, which defines infringing copy, was sought to be amended by specifically allowing for international exhaustion. However, this amendment was defeated in 2012 owing to active lobbying by publishers, wherein finally the Ministry of HRD came to a conclusion that post the amendment, a report on what kind of regime, copyright regime, exhaustion regime should follow would be commissioned, and NESR, that is National Council for Applied Economic Research, was commissioned this report, and they have come to a conclusion that in the interest of consumers and the benefits that are due to consumers by virtue of international exhaustion, it would be important that countries follow international exhaustion, and they have done a fantastic empirical study which is available on the website of the Ministry of HRD. In relation to exhaustion of trademarks in India, the provisions are quite unique in the sense that it has been highly contested in court decisions, and currently a case regarding whether India follows international exhaustion or national exhaustion in relation to trademark is pending in the Supreme Court. Now, if you look into Section 30 Clause 3 of the Trademarks Act, it reads that where the goods bearing a registered trademark are lawfully acquired by a person, the sale of goods in the market or otherwise dealing in those goods by the person or by a person claiming under or through him is not infringement of trade by reason only of A, that the registered trademark may have been assigned by registered proprietor to some other person after the acquisition of those goods, or the goods having been put on the market under the registered trademark may mark by the proprietor with his consent. The only exception to this provision is Section 4, which reads that subsection 3 shall not apply where there exist legitimate reasons for the proprietor to oppose further dealings in goods, in particular where the condition of goods has been changed or impaired after they have been put on the market. Now, in Samsung decision, which was decided initially by the single bench, Samsung Electronics versus Kapil Wadhwa 2012 decision, the single bench came to a conclusion that the regime in India under Section 33 read with Section 29, they came to a conclusion that trademark regime was national in character, exhaustion was national in character. However, this was immediately challenged in the division bench, and the division bench, looking into the objects and reasons of the act and the general principles of interpretation, have come to a conclusion that India follows international exhaustion regime for trademark. Primarily, the reliance placed by the division bench was on the objectives of the act, which clearly state that the reason for amendment was to specifically incorporate an international exhaustion regime in India, and they have made certain remarks over the single bench's decision where the interpretation and the interpretive techniques that were used by the single bench in relation to Section 33 of the act were not upheld by the division bench. However, as mentioned, this case has now gone to the Supreme Court, and we are expecting the Supreme Court to rule on the kind of regime of exhaustion that India follows in relation to trademarks. Now let's discuss certain specific issues in exhaustion relating to self-replicating technologies. Now, self-replicating technologies are those technologies wherein by virtue of the nature of technology itself, it makes copies. So if I were to buy a self-replicating technology and without my active involvement, if there is any kind of replication, would I be entitled to those copies that arrive out of such self-replicating technology is an important question. In Baumann versus Monsanto, decision of the Supreme Court of United States, the US Supreme Court came to a conclusion that in relation to self-replicating technologies, the regime of exhaustion that is followed would be the first sale doctrine. However, it applies only to the exact copy that was purchased from the buyer. Now, Baumann's argument was that since the technology is self-replicating, he should be allowed to save and resow the seeds and resell them by virtue of the first sale that occurred in relation to the original product that was purchased from Monsanto. So by virtue of this decision, the US Supreme Court came to a conclusion that if Baumann's argument in relation to first sale doctrine was adopted, then in self-replicating technologies, the IP owner, the patent owner, could never exercise effective control on further sales in relation to self-replicating technology, and it would directly compete with his market and monopoly. So the Supreme Court of the United States clearly said that although first sale doctrine applies in relation to patents, it was limited to the exact first copy that was sold to Baumann, and not to outcomes and produces in relation to self-replicating technologies. In this case, Baumann was replanting Monsanto's genetically modified plant varieties, and by virtue of these plants being self-replicating, he was using those seeds to resow them every year and was making profits out of it, and the Supreme Court struck down Baumann's claims in relation to first sale doctrine by limiting the scope of first sale as being applied to only that particular product which was sold to him, and not further copies of the product. Second is the issue of exhaustion of copyright in relation to products that are ancillary but do not directly infringe copyright. Now, in situations where suppose if the patent law allows international exhaustion, the trademark law allows international exhaustion, it is important because in India, since by virtue of court decisions national exhaustion is largely followed by most courts, it would be important to consider whether importation of products and ancillary infringement of copyright would be exempted. Now, in a situation where if you import a patented product or a trademark product, and if international exhaustion doctrine is applied, it will still be an infringement of copyright if there is valid copyright in labels and valid copyright involving artistic works. Now, to avoid this situation, in 2012 when the law was amended, the legislature clearly included a provision called 51ZC, which mentions that the importation of copies of any literary or artistic work such as labels, company logos, or promotional or explanatory material that is purely incidental to other goods or products being imported lawfully, this shall not amount to an infringement. Now, by virtue of this provision, if anybody were to import a kind of material that would in ancillary involve violation of copyright, it would not amount to copyright if it is otherwise valid under law to be imported. Now, this section is very unique, that because although national exhaustion regime does not apply in relation to copyright law, we have tried to create a minimum kind of small limitation in relation to a purely incidental infringement involving copyright. In summary, we may conclude that the property law principles do not allow to impose an absolute condition on sale which defeats the purpose of deriving value from the property, and hence any vendor cannot impose a condition which states that the buyer of the property cannot further sell it. This condition has been extended to intellectual property by way of the first sale doctrine, which means that a buyer of an IP protected product can further sell the same physical copy of the product and not make multiple copies. However, the first sale doctrine is going to help only with reference to the exact product and not the technologies that are reproduced. Furthermore, there are certain exceptions in relation to both cinematographic films and sound recordings, and also computer programs that are envisaged both in the TRIPS agreement and also in the domestic laws, where the basic idea is that in relation to these works there is no exhaustion or first sale in itself. We also discussed the principles involving national exhaustion and international exhaustion, wherein we have discuss the nuances of what it means to have national exhaustion where parallel imports are not allowed, and what it means to have international exhaustion where parallel imports are allowed in various kinds of intellectual property protected works. However, regional exhaustion is an extension to national exhaustion. We also discussed the arguments for and against international exhaustion. Primarily, the arguments have been relating to the fact that international exhaustion may discourage IP owners from price discrimination, and it is also important to understand that price discrimination, if not followed, would lead to consequences on consumers. So that has been the argument that IP owners have upheld. But we have seen that in relation to a large majority of IP protected products, in certain cases price discrimination may not be followed, and that's where exhaustion, international exhaustion, can be quite useful. In relation to TRIPS, we noticed that Article 6 of the TRIPS agreement does not lay down any kind of principle or definition of exhaustion. Hence, member countries are free to determine any regime of exhaustion provided it is consistent with other provisions of the TRIPS agreement, and provided you comply with section Article 3, that is national treatment, and Article 4, that is MFN, most favored nation treatment, in relation to the TRIPS agreement. In relation to exhaustion of patent rights in India, we notice that section 107 clause AB precisely does not clearly lay down any particular regime of exhaustion, but if you look into the statement of objectives and reasons and the amendments that were done in relation to clarifying the meaning of exhaustion, it leads to a kind of conclusion that the exhaustion regime that is adopted in relation to patent law is international exhaustion. However, there is a lot to be expected from the type of clarity that is needed in relation to this particular phrase imported from duly authorized by law from some other country, that needs to be clarified. In relation to copyrights in India, it's very clear from the court decisions that court decisions mostly have favored national exhaustion. We also discussed some off-bit decisions where parallel exportation has also been prohibited under Indian law, which is kind of per incurium. In relation to trademark law, we looked into the division bench decision in Samsung, and we have come to a conclusion that the principles of international exhaustion are clearly laid down in trademark law. However, this decision has been challenged in the Supreme Court. In specific issues relating to exhaustion, we discussed the Baumann versus Monsanto decision, wherein the Supreme Court of the United States has come to a conclusion that in relation to self-replicating technologies, the self-replicating technologies have an inherent ability to replicate, and in such situation there is in relation to such additional copies or the self-replicated ones, there is no exhaustion as such. So the exhaustion applies essentially to the first copy and not to further replicated copies. In relation to copyright copyright infringement of products that are imported and ancillary infringement, we know that the recent 2012 amendment has included a provision in relation to fair dealing under section 52, which allows that any kind of infringement as an ancillary to a product being imported, a copyright infringement in relation to a product being imported, is not considered as infringement within the copyright law. So in summary, we can come to a conclusion that although there has been an attempt by intellectual property owners to kind of argue and articulate a premise for international exhaustion, countries all around the world are moving towards in summary, we can conclude that although IP owners have been demanding national exhaustion, largely courts have all across the world have denied and have sought to interpret international exhaustion as the underlying principle, more in line with the objectives of free trade and in the welfare of consumers. Thank you one and all.